Power does what it wants. Power does what it wants. Power does what it wants.
You hear that, folks? There are two sets of laws. One for the police and one for the ordinary citizen.
Hello. Hey guys, Rogue Nation here with you. Today we're going to be going over the Social Security Administration. Some of you folks have seen my videos recently at the Social Security Administration. For the most part, I went out with Foshin. His channel name is S.S.A Public Service. He's doing really good work, guys. If you haven't seen his stuff, go check him out. I did get to one with James Madison Audits out in Leesburg, but and what we're going to do today is we're going to go over the law for photography for news purposes in the Social Security Administration. We got a case we're going to go over, and we're going to do a little question and answering with a judge on the topic. So hang on to your hats, and we're going to get into this. Alright guys, and the first thing I want to do is show my letter that I received the other day in the mail. And much like the one that this is a public service got, this basically says that I'm no longer allowed to enter to any Social Security Administration office, as you can see right here. It is a trespassing. Says your actions in the Orlando, Florida Social Security office violated our regulations. These regulations prohibit threatening or disorderly conduct on federal property. It says specifically on 1/30/2023 you were disorderly and disruptive. It doesn't say how. But basically it's a trespass notice. There is a 60-day there's a 60-day period there where you can submit your appeal. It must be in writing. So we're definitely going to be doing that. I did not get any citations in the mail with my trespass notice there, warning, whatever you want to call it. So as it is now, Foshin is the only one with citations for our activities in there. And I was kind of sad about that. I was hoping that I as well would get some citations, get some get some charges on this. But I feel that Foshin is a great representative of the community, and I believe that he's going to be able to handle these no problem. But he's kind of new, and it's always kind of shaky when you're new and getting charges, especially federal charges. But as you'll see here in this video, this is why he's going to win, and this is why I also wanted charges, because I also would have won, and we could help straighten out this whole mess. But to begin with, we're going to go ahead and start with the policy here. The law as far as filming for news purposes on GSA property, which the Social Security Administration falls under. This is the code 41 CFR 102-74.420. Okay, you could find that by just typing that into Google, and it'll bring you right up to where we are here. All right, so let's start. It says, what is the policy concerning photographs for news, advertising, or commercial purposes? Except where security regulations, rules, orders, or directives apply, or a federal court order or rule prohibits it. Okay, so we're going to start with that first, right? Because a lot of times trolls say, oh, well, you missed this paragraph. You didn't read the whole thing, blah. All right, so we're going to go over the whole thing. All right, so it says, except where security regulations, rules, orders, or directives apply. What you're going to notice here, first and foremost, is that policies do not fit in here, right? There's nothing here that says anything about a policy, okay? So right off the bat, people like to talk about the DHS memo, right? And in the DHS memo, it says specifically in there that Social Security offices have regulations that say you can't film in the Social Security office, right? Doesn't direct you to any regulation, right? There's no code or anything that you can look up there. It just says that the Social Security Administration has regulations that you can't film in S.S.A. offices, right? And they leave it at that. So you go over to the Social Security Administration and they have a policy manual. And they do have a policy that says that you can't film in Social Security offices, right? But as we can see from the highlighted part here, there's nothing in here that says policies trump the law, right? And we'll get into that with the judge later in our question and answering session, courtesy of Good Citizen News. All right. So now, if there were a security regulation, a rule, order, or directives, okay, if there were any of these, because we know there's not a federal court order or rule, and we'll get into why we know that here in just a minute. But if there were these things, these rules, these regulations, orders, then they would be listed, right? So you got a sign on the S.S.A. building on the windows when you come in, and it says photographs, recording not allowed per, and then they give this statute here, this 102, but it doesn't say that photographs and video recording are not allowed. As a matter of fact, it says specifically that persons entering in or on federal property may take photographs of building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. Now, let's break that down, okay? It doesn't say news personnel entering in or on federal property may take photographs of building entrances, lobbies, foyers, corridors, okay? Persons. Anybody going into the Social Security Administration can take pictures of building entrances, lobbies, foyers, and corridors, okay? You can also take pictures of auditoriums for news purposes, right? Because there's that Oxford comma, and then you have the or, right? It's not and auditoriums, right? Encompassing all of it. It's or auditoriums, right? You could take pictures in the lobbies, entrances, foyers, corridors, or you could take them in auditoriums for news purposes. It's not and corridors and auditoriums, right? It's not bringing those together, right? Separating. All right. So, getting back to the security regulations, rules, orders, or directives, there is none, right? All the stuff you guys have seen, the paperwork they've tried to hand me, and it all links back to this statute, right? So let's go down to part A. A lot of people, even some of our supporters, say, oh, you're reading it wrong, you know, A and B, they totally nix that out, right? So let's start here with A. It says space occupied by a tenant agency for non-commercial purposes only with the permission of the occupying agency concerned. Okay. So non-commercial purposes would be like tourists coming in taking photographs, news people taking pictures, right? Um, things like that, things where you're not monetized, or if you're a news agency, you can be monetized, but news agency is considered non-commercial, right? All right. It says space occupied by a tenant agency. Okay, so let's think about the wording they're using here, right? So, for example, if I have a glass here, right, and it encompasses this area, right? So, let's say it was solid. Let's say it was like a solid metal thing here, right? So, this occupies the space in my hand, right? This is what's occupying the space in my hand, is this glass, right? So, something else couldn't occupy that space, right? Because it's already occupied, right? So, in a public lobby, the agency is not occupying that space, right? There might be a chair occupying that space, right, that you can sit in, but the tenant agency is not occupying that space, right? It's kind of common sense. So that doesn't apply. B is pretty much the same thing, except it's for commercial purposes. All right, that would be like documentaries, filmmaking, anything where your intended goal is to make money on the product that you're putting together. We're out there doing it for news purposes, right? Or even personal purposes. You can use it here for as, okay, and we'll get to how we know that as well. So you could do that for any of these, right? So that's the law as far as that goes for the Social Security Administration, any GSA facility. Now, other federal buildings have different regulations, and we're going to get into that now. We're going to access a case, and this case was, let me go up to it and find it. It's United States versus Rosebrock. Okay. And these are the criminal minutes general and affirming order judgment of dismissal. Okay. So in this case, let's go here and read the background. On May 30th, 2016, on the Los Angeles campus of the United States Department of Veteran Affairs, VA police officer Ralph Garcia observed a appellee taking photographs of flags in an area of the VA property known as the Great Lawn. After identifying himself as VA police and advising the appellee that the taking of photographs on VA property without authorization for media use is not authorized, Officer Garcia asked the appellee what purpose appellee had in taking the photographs. Appellee responded that he intended to put them on a website and plaster you guys all over the net with news stories on you. After twice warning the appellee that continued unauthorized photography would result in a citation, Officer Garcia detained the appellee for unauthorized photography, as well as for placing and displaying the United States flag on a fence. Appellee persisted in taking pictures, and Officer Garcia advised appellee Rosebrock he would now be receiving a citation for unauthorized photography. Okay, and that's the same citation that Foshin got. Okay. Officer Garcia issued 2 citations for a violation of 38 CFR 1.218A10, taking photographs without permission, Central Violations Bureau, and 2 for a violation of 38 CFR 1.218A9, posting materials on property without authorization. Okay, and then on another incident, like a couple weeks later, somebody observed him recording video at Veterans Parkway on or near the VA campus in Los Angeles without permission or authority. They also issued him a citation for a violation of A10, taking video, recording photographs without permission. All right, and then so the magistrate court dismissed the charges against this guy, right? Then the United States, the federal government, appealed it. And this is the appeal, and this is them affirming the judgment of dismissal. Okay? So it's an order affirming judgment of dismissal. Now this has to do with the VA, but we're going to go down to page 7. D, other regulations of photography on federal property, right? And this is where it's going to get into a discussion of all the regulations on federal property dealing with photography. In support of its appeal, that's the United States government, appellant argues that there are Madrid federal regulations similar to the VA news photography regulations show that there is something uniquely disruptive about commercial advertising and news photography. A review of these regulations, however, reveals an inconsistent patchwork of rules for news photography on federal property. The General Services Administration regulation of news photography is facially similar to the VA regulation. Okay, so right there it's saying that the Social Security and the VA are similar as far as photographs for news purposes. It states that persons entering in or on federal property may take photographs of building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. Then they just quote the statute that I was just reading you. Nevertheless, the GSA regulation of photography as a whole is dissimilar to the VA regulation in that the GSA regulation limits photography for all purposes. And it does, right? It limits the news photography to just those areas, right? And it regulates the tenant agency's office, so they're right there. It regulates all photography there. Okay, the GSA regulation, where the VA regulation doesn't regulate photography everywhere, and we'll get into that and why that's true and why they said that. Okay, and then it gets into the GSA, why they do it. It says subsections A and B of the GSA regulation restrict photography taken for non-commercial and commercial purposes, respectively, without the consent of the occupying agency. And then it says the statute A and B. We read those. The universe of photographic purposes is restricted by these two subsections alone. No matter the photographic purpose, photographer must seek permission from the occupying agency, except when taking photograph authorized under the news photography subsection. Okay? Let me read that again for the trolls that can't understand. No matter the photographic purpose, a photographer must seek permission from the occupying agency, except when taking photography authorized under the news photography subsection. Subsection C, which permits news photography in certain locations, is best read as a qualification of subsections A and B. Permission need not be sought by persons who take photographs of building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. In contrast, the VA regulation does not purport to regulate non-news, non-commercial photography. See 38 CFR 1.218A10. The VA regulation does not contain a blanket prohibition on unauthorized photography. For example, one need not get permission to take photographs on VA property for personal use. Through the text of the news photography subsection of the GSA regulation is similar to the VA news photography provision, the GSA regulation separately restricts unauthorized news photography. Okay, and it restricts that by saying these are the only places you can take photographs for news purposes, right? So it restricts news photography to just these areas, whereas the VA policy doesn't restrict photography to just buildings, entrances, foyers, and corridors, okay? It also remains unclear whether it is possible to violate subsection C of the GSA regulation. Okay, now this is a federal district appeals court. It remains unclear whether it is possible to violate subsection C of the GSA regulation. The court is aware of only one case contemplating a charge under 41 CFR 102.74.420, and that's Askins versus Department of Homeland Security. The court in Askins examined a specific subsection of the GSA photography regulation, it's subsection A, which states that persons on federal property may take photographs of a space occupied by a tenant agency for non-commercial purposes only with the permission. The court held that a violation of 102.74.420A constitutes a crime. But Askins did not decide whether it is possible to violate subsection C of the GSA regulation, the analog to the VA news photography regulation. The other regulations appellant cites are dissimilar as well. Okay, and the appellant is the federal government. Okay. The conduct regulation for the United States Postal Service provides that photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings. 39 CFR 232.1, that's the post office, Poster 7 federal law statute. Okay. Yet the regulation also presents restrictions on all other photography, which may be taken only with the permission of the local postmaster or installation head. Okay? And it says they're construing the photograph regulations as creating a binary between photographs for news purposes and photographs for other than news purposes, without discussing photography for news purposes outside of designated areas. Similarly, 7 CFR 501.9, a regulation governing photographs at a Department of Agriculture Research Center in Nebraska, states that photographs for news purposes may be taken in entrances, lobbies, foyers, and auditoriums when used for public meetings without prior permission. The same regulation, however, has a separate prohibition on news photography using restrictive language. Photographs for news purposes may be taken in space or areas occupied by a cooperator only with the consent of the cooperator concerned and the director, the research center. Okay, and that's saying specifically for that Department of Agriculture Research Center. You can take photographs, lobbies, foyers, blah, 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 but if you want to take photographs in a space occupied by a co-operator, which is like saying a tenant agency, right? Co-operator. So if you want to take pictures in the space that's filled by the co-operator, you have to get their permission and the director's permission. Okay. They have other regulations here. They have one for Department of Agriculture, United States National Arbitorium. They've got photographs for the main Treasury Building and Treasury Building Annex. Department of Health and Human Services regulation permits photographies for personal or news purposes. And here it goes with the Public Park Service. Wherever commercial filming requires a permit in areas administered by the National Park Service, the Bureau of Land Management, and the U.S. Fish and Wildlife Service, generally, news gathering activities involving filming, videography, and still photography do not require a permit. Okay? Yet other regulations provide clear photography restrictions without carving out different rules for news photography. 4 CFR 25.11, That's the General Government Accountability Office building, and you can only record in there with their approval. All right. So it's probably restricted. There's probably no lobbies there, you know. So, and it says, finally, an oddity. Regulations governing photography at Smithsonian buildings are titled Photographs for News, Advertising, or Commercial Purposes, but those regulations only restrict photography for advertising or any other commercial purposes, not photographs for news purposes. In sum, there is no consistent scheme of regulating news photography on federal property. Regulations that contain provisions permitting news photography in entrances, lobbies, foyers, and the like often contain a separate clause prohibiting unauthorized news photography outside those locations. Okay? Other regulations classifying news photography separately from photography for other purposes often contain permissive language for news photography and restrictive language for other photography. Okay? And this is the construction of the VA regulation right here. And I'm going to let you folks go ahead and read over that and get into that yourself. Again, I'll have the link for this as the right under the description. It'll be the first link in the description so everybody can go over this case. But this is why it's going to be easy for us to beat. This pretty much lays out the fact that we have the right to go into entrances, lobbies, foyers, corridors. Okay? And there's never been a case, as this court pointed out, that says otherwise. Right? So that's going to be a no-brainer for that. Now, in the next part, we're going to ask some questions to a judge, and we're going to get his opinion on this whole situation. So hang on for that, and we'll get right to that. First, Judge, I want to thank you for being here with us today. And I was just wondering, is it possible for you to go over, like, who would be the news and you know, your legal understanding?
I'm not sure of the purpose of the news channel, such as it is. Everyone has a podcast. Everyone has a YouTube channel. Everyone is now a citizen journalist.
Now, I'm wondering, guys, can you explain this signage thing and you know, the policy, and if it does in fact trump law? Could you guys give us a little bit of understanding on that topic?
Renee is referring to this sign on the outside of the building, which states that it's federal law and Social Security Administration policy, and that says you can't do it without express written consent. So the federal law that is referring to would be what we're looking at right here, that if you're doing things for commercial purposes, you got to have written consent. And then the exception to all this is, you know, except otherwise a rule, an order, a directive, or whatever. It doesn't say anything about policy here. There's nothing in the rule that carves out an exception for First Amendment protection based on policy. It says rule, directive, court order, regulation.
Right, Judge, and I'm just getting that particular language from the Social Security Administration website itself.
No, I get it. Okay, I get it. Now I see where both sides are coming from. I think that the policy on the sign is in contradiction to the law on the books. And where the policy contradicts the law trumps. Title 41, Section 102-74.420 clearly gives a citizen the authority to record building entrances. Lobbies, I can't see how you would record a lobby without walking in it. Foyers, corridors, and auditoriums, and the memorandum of policy and procedure states, hey, we know folks are now coming in to do this. Let them do it. Let them do it. It is uncomfortable, but it is permitted. So the question then becomes, for me, doggone it, is the government following their own rules?
No, they're not.
I would just argue that once he starts recording people conducting business at the Social Security Administration, he is no longer following what the guidelines or the law is saying.
The spirit.
That's when it's no longer applicable to him, because that's what he's doing. He's not recording any of these other things. He's recording people actually doing their business there, and that's when he crosses. I would agree that at the beginning it's fine, but once he starts doing that,
And the court
Now, this is a good question here, because a lot of times the trolls say, well, you're recording people and they're in there doing their business and yada, yada, yada. You know what I mean? So I'd like to hear what the judge has to say about people being in these places that we're allowed to photograph and record, as the judge just said. We're allowed to be in there and record. But what happens if there's people in there conducting their business? Let's hear what they have to say on that.
I didn't mean to cut you off, Connor.
You're not.
The court noted earlier, made the distinction about sound. Yes, that person is in the shot, but we can't hear anything going on. We can't hear any business going on. He might as well be talking to the Social Security administrator worker in the hallway, not necessarily through glass, but there's no sound of any business. He's not trying to record someone's personal information and business for these news purposes. It's they're in a corridor.
Let's look then to the intent of the law as it's written to make a sound decision. If a person can record a building entrance, there are going to be people there. If they can record a lobby, there were obviously people there. And we can all agree that according to 420, he could just sit in the lobby and record that with those people in there. Corridors, if there are people in the corridors, they would just be caught on the camera. Auditoriums. It doesn't say if empty.
right, Judge. And I think there's a difference in the sense that they're actually, it's correct that that you can't hear what exactly they're talking about. But the very nature of those individuals sitting there at the Social Security Administration office, where most people may not want to be videotaped there.
Right.
I mean, I've had to do business there for myself at one time, and I certainly didn't want to be recorded there.
You want your privacy.
Exactly. And that, I believe, is what the spirit of the law is, Judge, is that...
Here's our problems, Mr. Serrato, me and you specifically. We're both rules followers.
Right.
You're a Navy guy, Army guy, Air Force brat. I was raised to follow rules. And that makes us good at bending to the will of authority that sometimes other people don't feel like they need to bend to, and they test the limits. And Mr. Lewis is testing the limits. And so I have to, as a judge, set aside my own nature of being a rules follower and actually follow the rules.
And in that spirit, Your Honor,
Right.
if we watch the video in its entirety, which is too long, you can hear Mr. Lewis several times stating on the video, he's quoting this exact rule. He's like, I'm in this location, it's for news purposes. And I know the summary that the state read talks a lot about being asked to leave and refusing, but a lot of those conversations are debating whether or not he can video there. And he just quotes, he's like, Section C, I'm in this area, it's for news purposes, I can video here.
He can video,
Right.
he can video there. He can video there.
And there are other portions of the video.
That's great news, guys. You heard it right from the judge's mouth. He can video there. He said it a couple of times. We're allowed to video in the lobbies. even when there's people there, because as he says, the law doesn't say when empty or if empty. It's just, it goes and fits so well and so smoothly into case law like Brandsburg v. Hayes, where it says the press and the public have the same right of access, right? So anywhere the public's allowed, the press is allowed, right? And this is a Supreme Court case. So why wouldn't that apply to a public lobby and a Social Security office? Why wouldn't that apply to a public lobby in the VA hospital? Why wouldn't it apply in the public lobby for the Department of Agriculture? If it applies to every state and every state building, then why wouldn't that apply to every public lobby and every federal building? So what he's saying, once you get the whole gist of the law, it all fits smoothly, right? And again, with like Price v. Garland, where it says recording is a non-expressive activity, that's why in a lot of these recording cases, they don't even bring up the public forum, right? Like if you listen to this case right here on Good Citizen News' channel, not one time did this prosecutor bring up that the inside lobby was a limited public forum or non-public forum. Didn't bring it up one time, right? Judge didn't bring it up. Nobody brought it up because it doesn't matter, right? Because public forum doctrine only restricts expressive activity, right? So while you could stand in line, wait and pay your utility bill in a nice and orderly fashion, what you can't do is be like, oh, all over the place, right? Because you're being expressive, right? So you're being disorderly. So it just makes sense. So I know a lot of people out there thought for a long time that you couldn't go into Social Security offices, but you can. You can go into them. You can go into the VA hospitals, and this is all law. This is all able to be looked up by yourself. I'll try to include some links. I'll have a link definitely for the court case I read off today. But I'll try to include a link for Good Citizen News' video here. And I'll try to include, I'll include the link to the court case, and that'll have all the federal regulations dealing with all the photography on federal properties that you guys need to look up. But yeah, it's just time that we took this right back, So you know what? I gotta hear about signage more though. So let me ask you, Judge, what if there's a sign up? Or what if they give, what if the police give me an order? What's that about?
And so there's also another statute that says that what is policy concerning the conformity with official signs and directions, that is 41 CFR 102-74.385.
Get there real quick. 41 CFR 402 102
74.385. That is, what is the policy concerning conformity with official signs and directions? Persons in and on property must at all times comply with official signs of a prohibitory, regulatory, or directory nature, and with the lawful direction of the federal police officers and other authorized individuals. Again, he wouldn't be.
But what if the sign is in direct opposition to what the law is?
So the sign, official signs.
It was an official sign.
Right. So I get it. There's a sign there. The sign clearly does not comport with the law. And what's so telling is this word lawful direction of federal police officers. I don't know if those guys are police, but their directions, if they're telling him he can't record in the areas where he was that are not prohibited by law, then their directions are not lawful.
And there is a conversation he has on the phone on the video with a federal protections officer, a federal officer. It seems to not have any problem with what he's doing. It's a mere fact people felt uncomfortable while he was doing it, and that's fair.
Now, Judge, what would be the outcome, do you think, if I was to end up getting arrested for a violation sort of similar to this?
Ultimately, as this thing goes through the court system, based on a plain language reading of the law, I believe that Mr. Lewis would be vindicated. And moreover, what the state is attempting to avoid would be now solidified in case law that he could do it, and more people will go and try it.
All right. Well, you heard it, guys. So, we're going to be out this week, man. We're going to be doing the VAs. So, keep your eyes peeled on that. Should be a rootin' tootin' good time, as it always is. And we'll keep you updated on Foshin's court date and our appeals process with the Social Security Administration. All right, guys. Thanks for watching.